The morning sun peeked through the tall windows of the county courthouse as Andre Taylor straightened his tie. It wasn't expensive, just a simple blue tie his grandmother had given him for graduation. The courthouse buzzed with activity, lawyers in $1,000 suits brushing past him without a second glance. Andre took a deep breath, clutching his worn leather messenger bag that contained just a few carefully selected documents. Today was the day. Housing discrimination case number 47293, Taylor versus Westview Properties, called the clerk, her voice echoing through the high ceilings. Andre walked forward, his shoulders back but his heart hammering in his chest. He had prepared for this moment for months, studying late into the night after finishing his shifts at the Community Legal Aid Center. The fluorescent lights highlighted the worn elbows of his suit jacket, the best he could afford after putting himself through law school. Judge Richard Bennett looked up from his papers, his glasses perched at the end of his nose. His eyes narrowed as he watched Andre approach the plaintiff's table alone. "You're representing yourself, Mr. Taylor?" Judge Bennett's voice carried a note of disbelief. "Yes, Your Honor," Andre replied, setting his bag down. The judge leaned back in his large leather chair, making it creak loudly in the otherwise silent courtroom. "And where is your attorney?" "I'll be serving as my own counsel, Your Honor," Andre said, his voice steady despite the butterflies in his stomach. A small laugh escaped from the defense table, where 3 attorneys in matching charcoal suits sat representing Westview Properties. Their lead counsel, a gray-haired man with a red tie that probably cost more than Andre's entire outfit, didn't bother hiding his smirk. The judge frowned. "You do realize, young man, that this is a complex discrimination case, not a simple traffic ticket?" "I understand the nature of my case very well, Your Honor," Andre replied. Judge Bennett sighed heavily, making sure everyone in the courtroom heard his exasperation. "Very well. Though I strongly advise you to reconsider. Westview Properties has one of the finest legal teams in the state." Andre nodded respectfully but stood his ground. He had faced doubt his entire life. From the high school counselor who suggested trade school instead of college, to the law school admissions officer who questioned if he could handle the workload. This was just one more person underestimating him. "Call your first witness, then," the judge said, checking his watch as if already calculating how much time this would waste. "Before I do, Your Honor, I'd like to present my opening statement," Andre said, stepping toward the center of the courtroom. The judge raised his eyebrows. "Without notes, Mr. Taylor?" "I know my case, Your Honor," the judge gestured impatiently. "Proceed, but keep it brief. We don't have all day." Andre stood tall, looking directly at the jury, a mix of 12 people who seemed to be sizing him up. He didn't pull out any papers, didn't refer to any notes. Instead, he began speaking from the heart, his voice growing stronger with each word. "6 months ago, I applied for an apartment at Westview Heights. I had perfect credit. I had 3 times the required income. I had excellent references. What I didn't have, apparently, was the right skin color." The defense table erupted with objections, the lead attorney jumping to his feet. "Your Honor, this is inappropriate and inflammatory." Judge Bennett held up his hand. "Mr. Taylor, this is exactly why self-representation is ill-advised. Save the emotional appeals for your closing arguments. Stick to the facts." Andre nodded respectfully. "The facts are what I'm here to present, Your Honor." The judge's face hardened. "Let me be clear, Mr. Taylor. I've been presiding over cases since before you were born. I've seen all manner of attorneys come through these doors. Those who succeed understand and respect legal procedure." He leaned forward. "Do you even understand basic legal procedure?" A hush fell over the courtroom. The defense attorneys exchanged satisfied glances. The court reporter's fingers paused over her machine. Even the bailiff seemed uncomfortable with the judge's tone. Andre took a moment before responding, refusing to be baited into an emotional reaction. "With all due respect, Your Honor, I graduated from Howard University School of Law last year. I'm well versed in legal procedure." "A recent graduate," the judge said with a dismissive wave. "That explains it. Should have hired a real attorney with actual experience." Andre felt the familiar sting of being judged not by his abilities, but by assumptions. He'd felt it when store security followed him around shops. He'd felt it when people crossed the street as he approached. And now he felt it in a place that was supposed to represent justice. "Your Honor," Andre said calmly, "the Constitution grants me the right to represent myself. I'm simply exercising that right." The judge's eyes narrowed at being challenged, however politely. Very well, Mr. Taylor. Continue your opening statement. But I caution you to stick to relevant facts. Andre nodded and turned back to the jury. His next words were measured and precise. Over the next few days, I will present evidence showing that Westview Properties has a pattern of rejecting qualified applicants of color. I will show emails between management discussing ways to maintain the character of the community. I will present statistical evidence showing that despite receiving applications from diverse candidates, their tenants remain overwhelmingly homogeneous. The lead defense attorney was scribbling notes furiously, while his colleagues whispered urgently. They had clearly expected an emotional, disorganized presentation, not this methodical approach. Andre continued, most importantly, I will show that when I sent my white friend to inquire about the same apartment just 2 days after I was told it was no longer available, he was given an application and told he could move in immediately. A juror in the back row raised her eyebrows. Another leaned forward slightly. Housing discrimination isn't always obvious, Andre said. It's rarely as blatant as a sign saying whites only. Today, it hides behind excuses like, we just rented the last unit, or your application was missing information. But the result is the same. Qualified people denied housing because of their race. Judge Bennett tapped his gavel lightly. Mr. Taylor, wrap it up, Andre nodded. Ladies and gentlemen of the jury, I'm not asking for special treatment. I'm asking for equal treatment. I'm asking for what the law already guarantees, the right to be judged by my qualifications, not my skin color. Thank you. He returned to his table, feeling the judge's critical gaze follow him. The courtroom remained silent for a moment before Judge Bennett cleared his throat. Well, that was more coherent than I expected, the judge said, unable to completely hide his surprise. We'll take a 15-minute recess before the defense's opening statement. As people began to move about the courtroom, Andre stayed seated, reviewing his notes for cross-examination. He could hear whispers around him, feel the stares. The defense team huddled together, occasionally glancing his way with new concern in their eyes. An older black woman who had been sitting in the back of the courtroom approached Andre. She leaned down and whispered, "They always underestimate us, don't they?" "Keep your head up, young man," Andre smiled and thanked her as she walked away. He returned to his preparations, knowing the real battle was just beginning. The judge had shown his bias early, but Andre hadn't come this far to be dismissed. His grandmother's words echoed in his mind. Sometimes you have to be twice as good to get half as much. So be twice as good. And that's exactly what he planned to be. The 15-minute recess stretched to 20 as Andre watched the defense team huddled in urgent conversation. Their previously relaxed demeanor had shifted. The lead attorney, Mr. Harrington, kept glancing toward Andre with narrowed eyes. Andre pretended not to notice, calmly arranging his documents while silently rehearsing the questions he would ask during cross-examination. When Judge Bennett returned, his robe swishing as he climbed the steps to his bench, the atmosphere in the courtroom had changed. There was a tension that hadn't been there before, a sense that something unexpected was unfolding. "Mr. Harrington, you may present your opening statement," the judge said. Nodding to Westview's lead attorney, Mr. Harrington stood, straightening his expensive tie. "Thank you, Your Honor. Ladies and gentlemen of the jury, what we have here is a simple misunderstanding blown out of proportion." As Harrington spoke, painting Westview Properties as a company with an excellent reputation that never discriminates, Andre listened carefully, making occasional notes. The defense's story was that Andre's application had been rejected due to a legitimate concern about his employment history. They claimed the rejection had nothing to do with race. Mr. Taylor was simply not qualified based on our standard criteria. Harrington concluded with a confident smile. The plaintiff's claims are baseless and frankly offensive to a company that prides itself on fair housing practices. Judge Bennett nodded approvingly at Harrington's presentation. "Thank you, Counselor. Mr. Taylor, call your first witness." Andre stood. "The plaintiff calls Ms. Diane Wilson." A middle-aged woman with kind eyes made her way to the witness stand. After being sworn in, she sat down, smoothing her skirt nervously. "Ms. Wilson, could you please tell the court your position at Westview Properties?" Andre asked. "I was the leasing manager for 3 years until 4 months ago," she replied. "And why did your employment there end?" "I quit," she said, her voice growing firmer. I couldn't be part of what was happening anymore. Mr. Harrington jumped to his feet. Objection, Your Honor. Calls for speculation and hearsay. I'm simply asking why she left her job, Andre responded calmly. Judge Bennett frowned. I'll allow it, but tread carefully, Mr. Taylor. Andre nodded. Ms. Wilson, during your time at Westview, did you receive any instructions regarding applications from people of color? Objection, Harrington shouted. Leading the witness. Andre didn't miss a beat. I'll rephrase. Ms. Wilson, what instructions did you receive regarding the processing of rental applications? The judge raised his eyebrows slightly, surprised by Andre's quick and proper adjustment. Ms. Wilson shifted in her seat. We were told to look for reasons to reject certain applications. If someone's name sounded, well, not white, or if their current address was in certain neighborhoods, we were supposed to find something wrong with their application. The jury leaned forward collectively. A woman in the front row frowned deeply. And if you couldn't find anything wrong? Andre asked. We were told to say the unit had just been rented even when it hadn't. Andre approached the witness stand. Ms. Wilson, do you recognize this email? He handed her a document. She glanced at it and nodded. Yes, this was sent by Mr. Reynolds, the property manager, to all leasing agents. Your Honor, I'd like to enter this into evidence as Exhibit A, Andre said, handing copies to the court clerk. So noted, Judge Bennett said, his tone notably less dismissive than before. Andre turned back to Ms. Wilson. Could you read the highlighted portion for the court? Ms. Wilson cleared her throat. Remember, we need to maintain the character of our community. Be creative with problematic applications. She looked up. We all knew what problematic meant. Harrington was on his feet again. Objection. The witness is interpreting the email beyond its text. Sustained, said the judge. The jury will disregard the witness's last comment. But Andre could see from their faces that the damage was done. The jury had heard it, and their expressions suggested they understood exactly what problematic had meant too. Andre continued his questioning. Methodically building his case through Ms. Wilson's testimony, he showed a pattern of rejected applications from qualified applicants of color, contrasted with accepted applications from less qualified white applicants. Each piece of evidence was presented clearly, each question asked with purpose. When it came time for cross-examination, Harrington approached Ms. Wilson with a predatory smile. Ms. Wilson, isn't it true that you left Westview Properties after being passed over for promotion? Yes, and isn't it true that you might harbor resentment toward the company for this reason? Andre stood. Objection, Your Honor. Counsel is badgering the witness and implying a motive without foundation. Judge Bennett paused, studying Andre with a slightly puzzled expression. Sustained, he said finally. Harrington looked taken aback. He'd clearly expected the judge to side with him automatically. Move on, counselor, the judge added. As Harrington continued his cross-examination, he grew increasingly frustrated. Each attempt to discredit Ms. Wilson was met with a calm, reasonable objection from Andre, many of which the judge sustained. By the time Harrington finished, sweat had formed at his temples, and he returned to his seat with a scowl. Mr. Taylor, call your next witness, Judge Bennett said, his tone notably more respectful than it had been at the start of the day. The plaintiff calls Mr. Thomas Reynolds, Andre announced. A balding man with a permanent frown made his way to the witness stand. As the property manager at Westview, Reynolds was responsible for the policies Andre was challenging. After being sworn in, Reynolds sat stiffly, his eyes darting between Andre and his own legal team. Mr. Reynolds, Andre began, how long have you been the property manager at Westview Heights? 8 years, Reynolds replied curtly. And during those 8 years, approximately how many tenants of color have lived in the building? Reynolds shifted uncomfortably. I don't keep track of tenants by race. Andre nodded. I understand. Fortunately, I've done that research for the court. He approached with another document. This is data from public housing records showing the demographic breakdown of Westview tenants for the past 8 years. Would you care to guess what percentage of your tenants have been people of color? Harrington jumped up. Objection. Counsel is asking the witness to speculate. I'll rephrase, Andre said smoothly. Mr. Reynolds, according to these public records, less than 3% of Westview tenants in the past 8 years have been people of color, despite the fact that this area's population is 47% non-white. How do you explain this discrepancy? Reynolds tugged at his collar. We simply rent to qualified applicants. I see, Andre said, approaching the witness again. And could you explain this email you sent last year? He handed another document to Reynolds, particularly the line that reads, "We need to be more careful about our screening process." The building's value depends on who lives there. The courtroom fell silent. Reynolds stared at the paper, his face paling slightly. That's not what I meant by that, he stammered. What did you mean, Mr. Reynolds? Before Reynolds could answer, Harrington objected again, this time on grounds of relevance. To everyone's surprise, Judge Bennett overruled him. I find this highly relevant to the case at hand, the judge said. The witness will answer the question. As the questioning continued, Andre cited legal precedents that surprised even the judge. When Harrington objected to a line of questioning about Westview's rejection rates, Andre immediately referenced a housing discrimination case from 1978 that few practicing attorneys would have known. Your Honor, in Harrison v. Palmer Management, the court established that statistical disparities in acceptance rates constitute admissible evidence when accompanied by supporting testimony, which I've provided through Ms. Wilson. Judge Bennett blinked, clearly caught off guard by Andre's knowledge of such an obscure case. That's correct, Mr. Taylor. Objection overruled. By the time the lunch recess was called, whispers were circulating throughout the courtroom. Court staff, other attorneys waiting for their cases to be called, and even the bailiff were watching Andre with newfound respect and curiosity. As Andre gathered his materials, he noticed Judge Bennett watching him with a puzzled expression, as if seeing him for the first time. The judge quickly looked away when their eyes met, but the moment hadn't gone unnoticed. In the hallway outside the courtroom, a young law clerk approached Andre. That was incredible, she said quietly. Where did you learn about Harrison v. Palmer? That's not even taught in most law schools, Andre smiled. My grandmother cleaned houses for a living, but she always told me education was freedom. I took that to heart. I study cases others overlook, he paused. Sometimes the most powerful precedents are the ones people have forgotten. As Andre watched the defense team huddled in urgent conversation at the far end of the hallway, he felt a quiet confidence growing. The judge's initial dismissiveness had been replaced with something else, confusion perhaps, or reluctant respect. Either way, Andre knew the real battle was just beginning. But for the first time since walking into the courtroom that morning, he allowed himself to believe that justice might actually be possible. Judge Bennett sat alone in his chambers, his half-eaten sandwich forgotten on his desk. The afternoon sun slanted through the blinds, creating stripes of light across the polished wood. He should have been reviewing notes for another case, but instead, his mind kept returning to the young man in his courtroom. Taylor. Andre Taylor. Something wasn't adding up. The judge prided himself on his ability to size up attorneys quickly, a skill honed over 3 decades on the bench. But he'd clearly misjudged this one. The obscure legal precedent Taylor had cited, Harrison v. Palmer, wasn't something you'd stumble across in basic law school courses. Bennett himself had only encountered it during a specialized housing law seminar years ago. With a sigh, he turned to his computer and typed, Andre Taylor, Howard University Law, into the search bar. The results loaded quickly, and Bennett's eyebrows rose higher with each click. Andre Taylor hadn't just attended Howard University School of Law. He'd graduated at the top of his class. There was a small news article about him, receiving the prestigious Morrison Fellowship for Civil Rights Law. Another link led to a paper, published in the Harvard Law Review, titled, Invisible Barriers, the Evolution of Housing. Discrimination in the 21st Century. Bennett clicked on the paper and skimmed the abstract. The analysis was sophisticated, the research thorough. This wasn't the work of a mediocre student who couldn't find employment. This was scholarship of the highest caliber. Another search revealed that Taylor had been offered positions at several prestigious law firms, Clarkson and Weber, Daniels Washington, firms that paid first-year associates more than Bennett earned as a judge. Yet Taylor had turned them down. Why? Bennett murmured to himself, scrolling further. The answer came in the form of a profile piece from a legal blog. Andre Taylor had established a small practice focusing on civil rights cases, particularly housing discrimination. He worked part-time at a community legal aid center, providing free counsel to those who couldn't afford representation. The article quoted him, "Law isn't just about making money, it's about making change." Bennett leaned back in his chair, a knot forming in his stomach. He'd assumed Taylor was representing himself because he couldn't afford an attorney, or because his case was too weak for any decent lawyer to take on. The truth was far different. Taylor had chosen to represent himself because this was his expertise, his passion, and Bennett had belittled him, had all but called him incompetent in open court. The judge rubbed his temples, remembering his own smug tone that morning. How many other times had he made similar assumptions? How many other litigants had he judged not by their words or actions but by his own preconceptions? A knock at the door interrupted his thoughts. "Come in," he called. His clerk, Patrice, entered with a stack of files. "Your calendar for tomorrow, Judge. And Mr. Harrington from the Taylor case asked to speak with you privately, but I told him all communications need to go through proper channels with the plaintiff present." "Good," Bennett said, taking the files. That was the right call. Patrice hesitated. "If you don't mind me saying, Judge, that young man Taylor, he's really something, isn't he?" Bennett nodded slowly. Yes, he is. I checked the docket. He's won 3 similar cases in other districts. Smaller ones, but still." She smiled slightly. "Just thought you might want to know." After Patrice left, Bennett returned to his computer, searching for those cases. Sure enough, there they were. 3 housing discrimination suits, all won by Andre Taylor, representing plaintiffs against property management companies. All with settlements that included not just monetary damages but required policy changes and anti-discrimination training. The realization hit Bennett like a physical blow. He wasn't dealing with an amateur fumbling through his first case. He was watching a gifted legal mind executing a carefully crafted strategy, one he had successfully implemented before. Meanwhile, across town, Andre sat at his small kitchen table, surrounded by papers and legal texts. His apartment wasn't much. A 1-bedroom unit in a neighborhood most of his former classmates wouldn't visit, let alone live in. But the rent was affordable, and it was close to the community center where he volunteered legal services on weekends. He took a sip of cold coffee and winced. It had been sitting there for hours while he reviewed his notes for tomorrow's witnesses. A stack of highlighted civil rights case law books teetered precariously at the edge of the table. His laptop screen showed dozens of open tabs, past discrimination cases, statistical analyses, property records. The day in court had gone better than he'd expected. He'd seen the shift in the jury's faces when Ms. Wilson testified about the problematic applications. He'd noticed how the judge's dismissive tone had gradually changed to something more thoughtful, more considering. Still, Andre knew better than to get his hopes up. He'd seen too many clear-cut cases of discrimination dismissed, too many corporate defendants walk away without consequences. His phone buzzed with a text from his grandmother. "How did it go today?" Andre smiled, typing back, "Good." The judge stopped looking at me like I was lost. His grandmother had been the one who'd pushed him toward law school, even when his high school counselors had suggested more realistic careers. She'd worked 2 jobs to help with his undergraduate expenses, had sat proudly at his law school graduation wearing her Sunday best. "You don't just need to know the law," she'd told him countless times. "You need to know how to use it." Andre returned to his notes. Tomorrow would be crucial. He'd be calling the former maintenance worker who had overheard conversations between management about keeping the building's standards up, a thinly veiled reference to keeping certain people out. Then he'd present the statistical evidence showing the stark disparity between Westview's tenant demographics and the surrounding community. He'd also need to be ready for the defense's witnesses. They would likely bring in current tenants of color, probably the same 3 people they always paraded out when accused of discrimination. He'd need to establish that these few exceptions didn't disprove the pattern. A knock at his door startled him from his thoughts. Opening it, he found his neighbor, Mrs. Chen, an elderly woman who often brought him home-cooked meals, worried that he wasn't eating enough. "You still working?" she asked, holding out a container of what smelled like dumplings. "It's late." "Young people need rest," Andre smiled, accepting the food gratefully. "Thank you, Mrs. Chen. Just preparing for court tomorrow." "Ah, the housing case. My nephew tried to apply at that building 2 years ago. Very qualified, good job at the hospital. They tell him nothing available. Next week his white friend goes. Suddenly they have 3 units. She shook her head. You show them, okay? I'm trying, Mrs. Chen. After she left, Andre ate while continuing to review his notes. He thought about all the Mrs. Chens, all the people who had faced those invisible barriers, who had been told nothing available when units sat empty, who had perfect qualifications but somehow never made it past the application process. This case wasn't just about his own rejected application. It was about a system that worked exactly as it was designed to, keeping certain communities segregated through methods just subtle enough to maintain plausible deniability. Around midnight, Andre finally closed his books. He needed sleep if he was going to be sharp tomorrow. As he got ready for bed, he glanced at the framed photo on his nightstand, himself at graduation, flanked by his grandmother and grandfather. His grandfather hadn't lived to see him argue his first case, but Andre carried his words with him. The law is like a door. Some folks want to keep it closed. Your job is to keep pushing until it opens for everybody. Tomorrow, he would keep pushing. Across town, in a much larger house in an exclusive neighborhood, Judge Bennett was still awake, still troubled. He'd found himself pulling books from his home library shelves, reviewing cases Andre had cited, reading papers on implicit bias in the judiciary. One paragraph from a judicial ethics paper had stopped him cold. Judges often mistake confidence for competence, mistaking the trappings of privilege, expensive suits, elite education pedigrees, familiar mannerisms for legal acumen. This unconscious bias undermines the very foundation of equal justice under law. Bennett had always considered himself fair, impartial, above such things, but his treatment of Andre Taylor had revealed something uncomfortable about himself, assumptions he hadn't even realized he was making. He pulled out the court transcript from that morning, rereading his own words. Should have hired a real attorney with actual experience. The words made him wince now. How many other times had he said similar things? How many cases had been affected by these unconscious judgments? Tomorrow would be different, he decided, placing the transcript aside. Tomorrow he would listen, truly listen, to the arguments presented. He would judge the case on its merits, not on his first impressions. As he finally prepared for bed, Bennett found himself wondering what might have happened if Andre Taylor had appeared in his courtroom in an expensive suit, with the backing of a prestigious firm. Would Bennett have treated him differently from the start? The uncomfortable answer kept the judge awake long into the night. The next morning brought a subtle but noticeable shift in the courtroom atmosphere. Andre arrived early, arranging his documents at the plaintiff's table with the same careful precision as before. But something was different. The court clerk smiled at him as she passed. The bailiff nodded respectfully. Even the court reporter caught his eye and gave a small, encouraging nod. When Judge Bennett entered, Andre rose along with everyone else, noting immediately that something had changed in the judge's demeanor as well. Gone was the dismissive frown, replaced by a thoughtful, almost contrite expression. As Bennett took his seat and called the court to order, he looked directly at Andre without the previous day's thinly veiled contempt. "Good morning, Mr. Taylor," the judge said, his tone markedly more respectful. "Are you prepared to continue with your case?" "Yes, Your Honor," Andre replied, trying not to show his surprise at the judge's changed manner. "Very well. Please proceed." Andre called his next witness, a former maintenance worker from Westview named Luis Rodriguez. As Rodriguez took the stand and was sworn in, Andre noticed the defense team shifting nervously in their seats. They hadn't expected him to find Rodriguez, who had left Westview 2 years ago after a dispute with management. "Mr. Rodriguez, what was your position at Westview Properties?" Andre began. "I was the head of maintenance for 7 years," Rodriguez answered, his voice carrying a slight accent. "And during that time, did you ever overhear conversations between management regarding tenant selection?" Rodriguez nodded. "Many times. My office was next to the leasing office and the walls were thin. Could you share what you heard?" "Objection!" Harrington jumped to his feet. "Hearsay, Your Honor." Andre was ready. "Your Honor, these statements would fall under the party admission exception to hearsay, as they were made by employees of the defendant in the course of their employment." Judge Bennett nodded. "Objection overruled. The witness may answer." Rodriguez leaned forward slightly. "I heard Mr. Reynolds and the leasing agents talk many times about applications. When certain people would apply, black folks, Latinos, Asians, they would find reasons to reject them. Once I heard Reynolds say, We can't have too many of them or property values will drop. A murmur ran through the courtroom. One juror, an older black woman, shook her head slightly. Did you ever confront management about these comments? Andre asked. Once. After that, they moved my office to the basement. Rodriguez's mouth set in a grim line. 6 months later, they let me go. Said it was budget cuts, but they hired someone new 2 weeks after I left. Andre continued his questioning, establishing that Rodriguez had an exemplary work record prior to his confrontation with management. When it came time for cross-examination, Harrington attempted to paint Rodriguez as a disgruntled ex-employee with an axe to grind, but Rodriguez remained calm and consistent in his testimony. After Rodriguez stepped down, Andre called a data analyst who had compiled statistics on Westview's rental patterns compared to similar properties in the area. The analyst presented charts showing that while the neighborhood was approximately 47% people of color, Westview's tenants were less than 3% non-white, a disparity that couldn't be explained by income differences, credit scores, or any other legitimate qualifying factors. Throughout this testimony, Judge Bennett listened intently, occasionally asking his own clarifying questions that suggested he was truly engaging with the evidence, not merely going through the motions. When Harrington objected to the statistical evidence as irrelevant, Bennett overruled him firmly. The statistical disparity is clearly relevant to establishing a pattern of discrimination, the judge said. The objection is overruled. By the lunch recess, the mood in the courtroom had shifted dramatically. The defense team huddled in urgent conversation, their earlier confidence evaporating. The jury members watched Andre with newfound respect. And Judge Bennett, before leaving the bench, did something unexpected. Mr. Taylor, he said, your presentation of evidence has been exemplary. This court appreciates thoroughness and attention to legal detail. It wasn't quite an apology for his earlier treatment, but the acknowledgement spoke volumes. Andre simply nodded his thanks, maintaining his professional composure despite the surge of validation he felt. During the lunch break, Andre stepped outside for fresh air, reviewing his notes for the afternoon session. He was preparing to introduce his most compelling evidence emails between Westview executives, discussing ways to discourage certain elements from applying without explicitly violating fair housing laws on paper, as he sat on a bench. Outside the courthouse, lost in thought, a shadow fell across his notes. Looking up, he was startled to see Judge Bennett standing there, looking somewhat uncomfortable. Mr. Taylor, Bennett said quietly, glancing around to ensure they weren't overheard. May I have a word? Andre stood, surprised by the unexpected approach. Of course, Your Honor. Bennett seemed to struggle with his words for a moment. I owe you an apology, he finally said. My treatment of you yesterday morning was unprofessional and unjustified. Andre hadn't expected this. In all his preparation, in all his imagining of how this case might unfold, he'd never pictured the judge approaching him with an apology. I've been on the bench for 30 years, Bennett continued. I like to think I've been fair, but your case has made me reconsider certain assumptions I didn't even realize I was making. Thank you for saying that. Your Honor, Andre replied carefully, mindful that they were still in the middle of an active case. Bennett nodded. I want you to know that going forward, this case will be decided strictly on its legal merits. He hesitated, then added, your brief on housing discrimination in the Harvard Law Review was impressively argued, by the way. With that, the judge turned and walked away, leaving Andre momentarily speechless. Bennett had researched him, had read his published work. The realization was both validating and sobering. It had taken exceptional credentials for the judge to see past his initial prejudice. When court reconvened, Andre prepared to present his key evidence. As he approached the bench with his exhibits, Harrington suddenly stood. Your Honor, may we approach the bench? He asked, his voice tight with tension. At the judge's nod, both attorneys stepped forward for a private conference. Your Honor, Harrington said in a low voice, my clients would like to discuss the possibility of a settlement. Andre kept his expression neutral, though his heart raced. The defense wanted to settle, a clear sign they recognized the strength of his case and feared a jury verdict. Judge Bennett looked at Andre. Mr. Taylor, your thoughts? I'm open to discussion, Your Honor, but any settlement must include not just monetary damages, but substantive policy changes at Westview. Bennett nodded. Let's take a 30-minute recess for the parties to discuss terms. As they moved to a private conference room, Andre felt a mixture of emotions. A settlement would be a victory, an admission by Westview that they couldn't win if the case continued. But part of him had wanted to present his final evidence, to lay bare the discriminatory practices for the public record. In the conference room, Harrington's false friendliness had vanished. Let's be realistic, Taylor. We're prepared to offer compensation for your rejected application and legal fees. In return, you sign a confidentiality agreement. Andre shook his head. That's not going to work. My terms are non-negotiable. Monetary damages, yes, but also a complete overhaul of Westview's application process. Regular audits by a fair housing organization for the next 5 years, and anti-discrimination training for all staff. That's ridiculous, Harrington scoffed. My clients will never agree to that. Then we continue in court, Andre said calmly. And I introduce my final evidence, the internal emails discussing how to maintain the building's character while avoiding explicit discrimination. The emails where Mr. Reynolds specifically mentions keeping out those people. The jury will love those. Harrington's face paled slightly. You're bluffing. You don't have those emails. Instead of responding, Andre simply opened his laptop and turned it toward Harrington. On the screen was an email chain with the Westview executives obtained through discovery. Harrington scanned the contents, his expression darkening. How did you get these? He demanded. Proper legal discovery, counselor. The same process you've been stonewalling for months. Andre closed the laptop. Now about those terms. 20 minutes later, they returned to the courtroom. Judge Bennett looked between them inquiringly. We've reached an agreement. Your Honor, Andre announced, as Andre outlined the settlement terms, the monetary damages, the policy changes, the ongoing audits. He watched the faces of the jury members. Several nodded in approval. The older black woman in the back row gave him a small smile. Judge Bennett listened to the terms, then addressed both parties. This seems like a fair and comprehensive resolution. I'll review the formal agreement once it's drafted. Then, looking directly at Andre, he added, Mr. Taylor, your advocacy in this case has been exceptional. The court commends your preparation and legal acumen. Coming from the same judge who had belittled him just the day before, the words carried special weight. Andre nodded his thanks, maintaining his professional demeanor despite the triumph he felt inside. As court adjourned, people began filing out. Several jurors nodded respectfully to Andre as they passed. The court reporter stopped briefly to congratulate him. Even the bailiff gave him a small thumbs up when no one was looking. Outside in the hallway, a young law student approached him hesitantly. Mr. Taylor? That was amazing. The way you cited Harrison vs. Palmer and linked it to the statistical evidence. Would you mind if I asked you a few questions sometime? I'm hoping to go into civil rights law myself. Of course, Andre said, handing her his card. My office isn't fancy, but the door's always open to anyone who wants to use the law to make real change. As he gathered his materials to leave, Andre caught sight of Judge Bennett watching him from down the hallway. The judge gave him a small, respectful nod, an acknowledgement not just of Andre's legal victory, but of his own journey from prejudice to recognition. Andre returned the nod, a silent understanding passing between them. Some victories happened in the courtroom, documented in legal decisions and settlement agreements. But others, perhaps the more important ones, happened in the human heart, in moments when old assumptions fell away, making room for new understanding. 3 months after the Westview case settled, Andre sat at his desk in his new office. It wasn't large or luxurious, just a modest space in a renovated brownstone that he now shared with 2 other civil rights attorneys. But the walls were freshly painted, the windows let in plenty of natural light, and most importantly, it was his. The settlement money had allowed him to expand his practice, though he'd put most of the funds into establishing a legal aid clinic in his grandmother's neighborhood. The real victory hadn't been the money anyway. It was seeing Westview Properties implementing the promised changes, with regular fair housing audits now part of their operations. A knock on his open door pulled Andre from his thoughts. His assistant Lily stood there with a thick envelope. This just arrived from the courthouse, she said, handing it to him. Looks official. Andre opened the envelope and pulled out a formal document. As he read, his eyebrows rose in surprise. It was an appointment to the city's Fair Housing Commission, a volunteer position, but one with real influence over housing policy. At the bottom was a personal note from Judge Bennett. "Mr. Taylor, your expertise would be invaluable to the commission. I've recommended you personally. The choice is yours, of course, but few would bring your combination of legal knowledge and personal commitment." Judge Richard Bennett? Andre set the letter down, stunned. 3 months ago, Bennett had barely disguised his contempt for him. Now the judge was endorsing him for a position of real authority in the city's housing policy. His phone rang, his grandmother calling for their weekly check-in. "Hey, Grandma," he answered, smiling. "There's my lawyer," she said, pride evident in her voice. "How's that fancy new office? Still getting used to having an actual conference room instead of meeting clients at the coffee shop?" Andre laughed. "But it's good. Really good. Any interesting cases?" "A few, but something else just happened." He told her about the appointment letter and Bennett's note. His grandmother was quiet for a moment. "You know what this means, don't you? You didn't just win your case. You changed that man's mind. That's harder than winning in court." Andre thought about that after they hung up. His grandmother, as usual, had cut straight to the heart of the matter. Changing laws was one thing. Changing hearts and minds was something else entirely. Across town, Judge Richard Bennett was holding a training session for new judges. It was something he'd never done before. But after the Taylor case, he'd volunteered to lead a workshop on recognizing implicit bias in the courtroom. "The robe doesn't make us immune to bias," he was telling the group of newly appointed judges. "If anything, it can make our biases more consequential." A young judge raised her hand. "But we're trained to be impartial. That's the whole point of being a judge." Bennett nodded. "Yes, and most of us truly believe we're being impartial. But impartiality isn't our natural state. It's something we have to work at continuously." He paused. "Let me tell you about a case that changed my perspective." He shared the story of Andre Taylor, how he'd initially dismissed the young attorney based on appearance and assumptions, how he'd been humbled by discovering Taylor's impressive background, and how the experience had forced him to confront biases he hadn't even realized he held. "I've been on the bench for 3 decades, Bennett told them. "I'd like to think I've been fair. But that case made me ask myself, how many others have I misjudged? How many litigants receive subtle signals that I didn't respect them or take them seriously, simply because they didn't fit my image of what a qualified person looks like?" The room was quiet as the new judges absorbed his words. "Our system is only as just as the people administering it," Bennett continued, "and that starts with recognizing that we bring our whole selves to the bench, including our biases. The question isn't whether we have biases. The question is what we do about them." After the session, Bennett returned to his chambers and found a message waiting. Andre Taylor had accepted the appointment to the Fair Housing Commission. Bennett felt a surprising sense of satisfaction. The commission needed people like Taylor, people with both the legal expertise and the personal commitment to housing justice. 6 months later, Andre stood at a podium in a community center, addressing a room full of law students and community members. Behind him was a sign that read, "Know Your Rights, Fair Housing Workshop." Housing discrimination doesn't always announce itself, he was explaining. Today's landlords and property managers rarely say, "We don't rent to your kind." Instead, they say, "Sorry, the unit was just rented," or "We need additional documentation," or "Your application is missing information." The audience nodded, many with knowing expressions. But the law doesn't just prohibit explicit discrimination, it also prohibits practices that have a discriminatory effect, even if they seem neutral on paper. A student raised her hand. "But how do you prove that? If they don't say anything explicitly discriminatory, how do you show it in court?" Andre smiled. "Good question. That's where both data and testimony come in. Patterns tell stories that individual rejections might not." As he continued the workshop, Andre noticed a familiar figure slip into the back of the room, Judge Bennett, dressed in casual clothes rather than his judicial robes. Their eyes met briefly, and Bennett gave a small nod of acknowledgement. After the workshop, as people gathered in small groups to ask questions, Bennett approached. "That was an excellent presentation, Mr. Taylor," he said. "Clear, informative, accessible to non-lawyers." "Thank you, Your Honor," Andre replied. "I'm surprised to see you here." Bennett shrugged slightly. I'm trying to get out of the courthouse more, see what's happening in the communities affected by my rulings. He paused. Your work on the Fair Housing Commission has been noticed. The policy recommendations you drafted are gaining traction with the city council. Andre nodded, still somewhat surprised by the judge's presence. It's a start, though there's a long way to go. There always is, Bennett agreed. He hesitated, then added, I've been recommending your Harvard Law Review article to my colleagues. It sparked some interesting conversations among the judiciary, the thought of judges discussing his work, perhaps questioning their own assumptions the way Bennett had was both surprising and gratifying. A young woman approached them, clutching a legal pad full of notes. Mr. Taylor, could I ask you about internship opportunities at your clinic? I'm a first-year law student and, of course, Andre smiled, then turned to Bennett. Excuse me, Your Honor, Bennett nodded. Keep up the good work, counselor. As Andre spoke with the student explaining the clinic's mission and internship program, he reflected on how much had changed in less than a year. From being belittled in open court to having his work discussed among judges, from representing himself in a discrimination case to helping shape city housing policy. The clinic he'd established was now serving dozens of clients facing housing discrimination. 2 major property management companies had revised their application processes after facing similar lawsuits, and most surprisingly, a judge who had once dismissed him out of hand was now recommending his legal scholarship to colleagues. Later that evening, Andre visited his grandmother, bringing dinner and updates about his work. As they sat at her kitchen table, the same table where he'd studied for the LSATs, where he'd completed law school applications, where he'd prepared for the bar exam, he told her about the workshop and Bennett's unexpected appearance. You've come a long way, she said, patting his hand. Your grandfather would be so proud. I still have that moment sometimes, Andre admitted. Walking into a courtroom and seeing that look like I don't belong there. His grandmother nodded knowingly. Some doors are heavier than others. Doesn't mean you stop pushing. I know. Andre smiled. I learned that from you. As he drove home that night, Andre thought about all the invisible barriers that remained, all the systems that still functioned to exclude, rather than include. One case, one judge, one policy change, these were just drops in a very large bucket, but drops could accumulate. Minds could change. And sometimes the most powerful argument for justice wasn't a legal precedent but a personal one, showing rather than telling, proving through excellence what should have been assumed from the start. The next morning, Andre arrived at his office early. On his desk was a stack of new housing discrimination complaints, people who had heard about his victory against Westview and hoped he could help them too. Next to them was the draft of a fair housing ordinance he was helping the city council develop, stronger than anything they'd considered before. He hung up his coat, made a cup of coffee, and got to work. There were still doors to be opened, still barriers to be dismantled. And while a courtroom victory was satisfying, the real work happened in the days and years that followed, in changed policies, in reformed systems, in shifted perspectives. As he reviewed the first case file, Andre thought about Judge Bennett, about how even someone entrenched in the system for decades could still grow, still learn, still change. If that was possible, perhaps anything was. Outside his window, the city was waking up, and in offices, courtrooms, and community centers across town, the quiet work of justice continued, not in grand gestures or dramatic confrontations, but in the persistent, patient push toward a world where people were truly judged by the content of their character, not the color of their skin or the assumptions attached to it.